Hello, everyone. I'm Alex Rushing, a partner in Husch Blackwell's Higher Education Group. Thank you for joining our program today. Before we begin, I would like to cover a few housekeeping items. At the bottom of your audience console, there are multiple application icons for your use during the program today. If you have any questions during the webcast, please submit via the question box. We will have a lot of content to cover today, but we'll try to answer as many questions as we can during the webcast today. A PDF of the presentation is available in the program materials folder. This program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of the screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing at your institution. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan future programs that are applicable to your educational needs. This program was the result of multiple submissions discussing this topic in those surveys, so we really do focus on your answers to those survey questions. Keep those coming, please. Presenting with me today is my wonderful colleague, Claire Hawley. Claire is a rising star in our education group in Kansas City, who practices across the country and has a wealth of experience in litigation, investigations, and compliance issues. Claire has dedicated her career to navigating the complex legal landscape of higher education law. That is it for the housekeeping items, and so we will move on to our agenda. Like I said at the beginning, we have a very packed agenda of what we plan on covering today, but rest assured we do have a recording of the session. So if we do go over time, please feel free to hop off at the 1 o'clock hour Central Time, and you will get a recording of the session to complete the rest of the training. So with that, we will dive in and get started with Title IX and athletics. If your institution has student athletes and you have not seen a Title IX related issue come up this past school year, consider yourselves lucky. We have seen so many gender equity issues, whether that be internal complaints, OCR complaints, and even litigation. So this is why we're really starting with this area. And for any of you who have heard my prior presentations, I have a favorite kid among my two sons. I have a favorite area of the law, and that is absolutely Title IX, and gender equity is no different. So let's dive in. Let's start with a little bit of a history related to gender equity in athletics. Contrary to popular belief that Title IX was passed to create gender equality in sports, the Title IX statute does not reference athletics programs. Instead, athletics programs requirements are specifically addressed in Title IX regulation, which became effective in 1975, actually. When this proposed regulation was published in June of 1974 in the Federal Register for comment, there were nearly 10,000 comments that were received during that comment period. Most of those comments related to athletics. Congress passed Section 844 of the Education Amendments of 1974, which required inclusion in the Title IX regulation the following language: with respect to intercollegiate athletics activities, reasonable provisions considering the nature of the particular sports. So that's where we see some of that language come from. We know Title IX covers more than just athletics. It also prohibits discrimination based on sex in education programs or activities. For all of you as recipients of federal funds, here are some of the common areas of education programs or activities on your campuses. And we have a new software that we're using with our webinar system. And so our slides are not moving nearly as quickly as I want to move today. So I'm gonna have Claire navigate the next slide to advance them so that we're making sure we cover all the content. So if we could push to the common areas of challenges, that would be wonderful. And we will move ahead with our session. So keep in mind, Title IX has broad coverage. It is so critical to keep this in mind that Title IX covers more than just sexual harassment, obviously gender equity in athletics, pregnancy and parenting, scholarships, etc. And that's why we work with our clients to think through managing all of your Title IX operations. Is one Title IX officer enough? What about deputies? Do you want to divide up the deputies based on a college or university constituents or a specific subject area? What about training? Those are some of the things to think about in the common areas of challenge within your institution in this space. Who makes the decisions about how to route a report depending on the nature of the report? The complainant, the respondent, the parties involved, etc. We can advance to the next slide. Are those involved in Title IX processes aware of conflicts of interest and bias? Is your bench deep enough to manage any conflicts that may arise? Those are some of the things you wanna think through from a big picture. As you all know, and as we've discussed, athletic programs are considered educational programs and activities, and there are three basic parts of Title IX as it applies to athletics, as you will see on your screen. And we'll dive into these in a few slides. Sexual harassment is obviously also covered, like we talked about, within the Title IX requirements. Regarding compliance for this area, that comes to us from the 2020 regulations, which will likely see changes this spring or maybe even this summer. We're not going to dive into that on this particular session today, but we do have great trainings coming up on February 27th, February 28th, and March 28th related to those specific topics if you wanted to dive into sexual harassment. So then we'll move on to the next slide, talking about why compliance actually matters. The reason compliance matters includes what's on your screen, but it's not just limited to that. That's what we're going to focus on today. First, the possibility of a complaint being filed with the Office for Civil Rights within the U.S. Department of Education, or a lawsuit being filed against your institution. The latter action became more prevalent after 1992, when the Supreme Court in Franklin versus Gwinnett ruled that monetary damages could be awarded in Title IX cases. So let's move on to the next slide, where we're going to talk about the three-part test of compliance. This test includes participation, scholarship, treatment, or benefits. When we think of participation, Title IX requires that women and men be provided equitable opportunities to participate in sports. Title IX doesn't require institutions to offer identical sports for an equal opportunity to play. Scholarships under Title IX requires that female and male student athletes receive athletic scholarship dollars proportional to their participation. And then for the treatment or other benefits portion, Title IX requires the equal treatment of female and male student athletes in the provisions of the laundry list of items, which we'll go over shortly. So let's dive into that first part, the equitable participation on this slide. Keep in mind, your institution only needs to meet one of the prongs for compliance with the equitable participation requirement. Prong one, the substantial proportionality. This compares enrollment numbers for full-time undergraduate enrollees with the number of participants in intercollegiate athletics. One of you asked, actually, in the questions that I've seen come through on the chat, who counts as an athletic participant? I'm so glad you asked this, because OCR has told us that athletic participants are athletes who receive institutional support normally offered to student athletes, participate in organized practices and team meetings, are listed on the team squad or eligibility list for each sport, or are considered injured but continue to receive financial aid based on athletic ability. Athletic opportunities are considered substantially proportionate when the number of opportunities that would be required to achieve proportionality would not be sufficient to sustain a viable team. So let's go through prong two. This relates to the history and the continuing practice of a program expansion. Here, OCR will review the entire history of the athletic program, the focus on participation opportunities, look for a demonstrative evidence related to expanding those opportunities in response to interests and abilities. Keep in mind that there's no fixed intervals of time and no fixed number of sports. Instead, the key is that program expansion is responsive to the interests and abilities. Sometimes this prong is described as a bridge to prong three when you're not meeting that substantial proportionality prong. For prong three, this requires a showing that the higher education institution is fully and effectively accommodating the interests and abilities of the underrepresented gender. Here, there are three questions to answer. Are there females who are interested in competing in a particular sport? Is there sufficient ability among them to sustain a team in that sport? Is there a reasonable expectation of competition for that team? If the answer to all of these questions is yes, and the university is not making a corresponding effort, then the school would not be meeting this prong of the test. If the answer to any of these questions is no, then the university would be meeting this prong and consequently would be compliant with Title IX's requirement to provide both genders equitable participation. So now we'll move on to the next slide related to equitable financial support. Part 2 of the 3-part test restates the equitable financial support. We see the language from the regulation on the screen, but let's break that down exactly what that means on the next slide. OCR has stated that when a disparity in athletic financial aid is 1% or less, there's a strong presumption that the disparity is reasonable and is based on legitimate non-discriminatory factors. But if the disparity is more than 1%, there's a strong presumption that this is in violation of the substantially proportionate requirement. So for example, if female athletes make up 46% of an institution's athletic participants, then OCR expects that the female athletic scholarship budget would be between 45% and 47% of the total budget for athletic scholarships for all athletes. OCR has said that institutions are not required to provide the same number of scholarships for men and women or scholarships of equal value. Instead, a university's Title IX compliance hinges on the substantially proportionate test, and that's a common myth that we've seen across the industry. So on the next slide, you'll see the final part of the test, and that's equitable treatment. This is oftentimes referred to as the laundry list. The laundry list includes a deep dive into the athletic department's operations to determine if there is a disparity and why that disparity exists. That's really the secret sauce there. Let's take a look at the next slide to see what is included within that laundry list. When we're doing privileged gender equity reviews for schools, this is the list we cover of all the items for the laundry list. This is meant to be comprehensive. Compliance is determined by an evaluation of the entire athletics program as a whole, rather than a particular female team or amenity compared to a particular male team or amenity. Each of the laundry list items must be assessed, comparing the resources provided male and female student athletes with consideration of factors like availability, quality, kinds of benefits, opportunities, and treatment. OCR has acknowledged that the evaluation of this laundry list can be difficult, which is appreciated, and also stated that generally a pattern of discrimination is evident if it appears that athletes of one sex are accorded second-class status, and that's a direct quote from OCR. We'll turn to the next slide and you'll see some questions to be asked for each component that you'll see on your screen. But I want to do a little myth busting here because some questions I'm seeing come through the chat on this. Let me be clear, having an equitable budget does not equate to compliance for from a gender equity standpoint. There is no requirement that men's and women's teams of the same sport be treated equally. But if there are disparities between men's and women's team in the same sport, they should be mitigated for the affected sex in another area. Don't assume differences are disparities. That's another myth. That's not how we look at it, nor how OCR views it. So long as those differences are the result of non-discriminatory factors, that's really going to be your key. So now we're going to move to the next slide and talk a little bit about the NCAA sexual violence training and reporting. So as you'll see on the next slide, if we move ahead, if you're an NCAA higher education institution with student athletes, you're likely well aware of this training requirement for your student athletes, coaches, and staff. The next slide you'll see, in addition to that training requirement, the NCAA also requires incoming and transfer students to disclose conduct that resulted in Title IX discipline or a crime of violence conviction. An institution participating in NCAA athletics must take reasonable steps to confirm whether incoming, current, and transfer students have been disciplined under Title IX or convicted of a crime of violence. Sometimes I see schools overlook the current student part of that requirement, so keep that in mind. The NCAA also requires a sharing of relevant disciplinary information and Title IX outcomes with other NCAA schools where a student seeks to transfer and enroll. And finally, having a procedure for gathering information on completed and pending Title IX proceedings and criminal convictions as part of the recruiting process. So if we move to the next slide, some of the things to think about in terms of implementing those requirements are on the screen. You want to develop an overall policy and process that works logistically for your institution's specific needs. Remember, this is not a one-size-fits-all approach. Make sure you're developing a student self-questionnaire or verification, a release of information form for previous institutions, and an annual attestation form. And you'll see these if we move ahead one more slide. Think through before you have a situation come up what infrastructure and reporting channels you have in place related to the requirements when a matter comes in that triggers one of these requirements. In terms of the role your athletics administrators and coaches have, if we move along to the next slide, here are some of the common ways we've seen in our practice, but there's so much more than just the list that's going to appear on your screen. And so we want to think through what your institutional needs are, cooperation with a Title IX coordinator, implementing supportive measures, and making players and staff available as needed. With that, I'm going to turn it over to my colleague, Claire, to talk about student conduct issues. Claire.
Hi, Alex. Are you still there? Okay, I cannot hear you. We're having some technical difficulties with On24 today, so I could not unmute, and now I cannot hear you. Can you hear me? Okay, I'll move forward then. Okay, thank you, Alex, and thank you all for bearing with us. We've just had an update with this system, and it's testing our patience today, so I appreciate you guys. So we're going to start with the purpose of a student code of conduct. I can't see the slides, so Alex or Tori, if you could move them, that'd be great. Thank you. So we're all familiar with common conduct provisions like don't commit plagiarism or don't threaten or harass others. But why do we have these in the first place? And what's the purpose of a conduct policy? So at their core, these policies are educational. They set expectations for the learning and living environment, as well as requirements for eligibility to remain a part of the community. So often they'll embody or incorporate the values of your institution. Conduct policies are not about punishment or retribution. That's a criminal law function. They aren't about total protection like you'd expect to see in a K-12 environment. Courts no longer require colleges to stand in loco parentis of their students, and they aren't about shared governance or institutional differences. That's a faculty handbook. So while this framing may seem fairly basic, you might be surprised at how often student conduct policies veer off course. So how this document is drafted and implemented impacts the community in significant ways. So it's crucial to keep education and safety at the fore. And then we can go ahead and move to the next slide. So key issues to consider when you're drafting or implementing a conduct policy. There are a lot of variables. So first and foremost, it's identifying which laws you have to follow. So in reviewing our attendee list, we're very lucky to have a diverse audience today with an equally diverse set of laws that might apply, depending on whether you're public or private and depending on your state and federal jurisdiction. So if you're a public school, you know that you're subject to the federal Constitution, the First Amendment, the Fourth Amendment, substantive and procedural due process. Those are all laws that can apply to how you administer your conduct process. You may also be able to assert sovereign immunity depending on the claim. For private schools, the Constitution does not apply to you, but you can still face breach of contract claims. In many jurisdictions, courts hold that conduct policies generally are an implied contract with students. The courts are generally differential on these claims to universities and really only hold universities liable for breach where the breach was arbitrary and capricious, typically requiring a showing of bad faith. So both public and private schools are subject to claims that the conduct policy was administered in a discriminatory manner, which could be brought under Title IX, Title VI, the ADA, or Section 504 of the Rehabilitation Act. And state law claims may be available as well. On that discriminatory claims, a common source is a state law Human Rights Act. And so the second variable to consider is how your conduct policy might relate to other policies that you have. In some cases, maybe even overlap with them. So don't draft or implement conduct policies in a vacuum. Think about how they might intersect with your Title IX policy, your residential life policies, your disability services or accommodations policies, and your athletics policies. And third and finally, consider the scope of your policy and the jurisdictional or any practical limitations that you might have to enforcement. So for example, how far does the code extend? Does it apply to all conduct regardless of whether it occurs on or off campus? And then we can move to the next slide. So It goes without saying that the way that you enforce your code matters. And these are examples of some of the most common procedural and substantive mistakes, things that if conduct cases progress to litigation, things litigators might refer to as bad facts. So on the procedural side, the first is a conflict of interest. These are fairly easy to avoid, provided you have large enough of an institution. Just make sure the decision maker isn't biased against the student or otherwise conflicted. Also, just make sure that there's an appellate review option and the appellate decision maker isn't the same person as the initial decision maker. And one good way to address potential conflicts challenges is to also give the students an option to challenge the appointed decision maker on conflicts grounds. And then notice. So adequacy of notice is absolutely key. And this means that the student is given a description of charges or alleged code violations, a summary of the factual basis for those charges, and an explanation of their procedural rights, as well as a right to representation. And the timing of this notice is also really important so that the student has a reasonable time to prepare and respond. And as I just alluded to, students should be given an opportunity to be heard. But what does this mean? If you're a private school, the specifics will depend on your policy language. But generally, and for public schools, it means a sufficient opportunity to present, review, and cross-examine information to witnesses. And a less common issue we see is the failure to consider information or explain a decision. So moving to the common substantive challenges, the most common that we probably see is that the evidence was insufficient. So if you have a well-reasoned written decision that's grounded in objective evidence, this shouldn't be a concern, but this is always why it's a really great idea to have an appeal option, because appeals will add another procedural layer, and that comes at the expense of administrative time and resources, but they're a great safeguard, especially if something devolves into litigation. And as I mentioned earlier, the appellate officer should never be the original decision maker. And the second substantive challenge is that the punishment didn't quite match the crime. Or in other words, the sanction was too harsh. So in your policy, we recommend spelling out what sanctions are possible for each specific violation. That goes to notice, and it kind of undercuts this penalty was too harsh argument. But also to ensure that sanctions are consistent, you may consider developing an internal protocol, akin to maybe like a sentencing guideline where you consider various factors, or if it's a second-time offender, it's elevated to a certain degree, things like that, just to make sure that your code is being applied consistently. Okay, and then we can move to the next slide. So this will bring us to our fourth topic. This is supporting at-risk students, and we can move to mental health on college campuses, because statistics really help put mental health on college campuses into context. It's such an important issue. And the statistics can be really jarring. So over half of college students are lonely, according to the clinical definition of loneliness from the American College Health Association. And over half of college students experience moderate psychological stress, while another 1/4 experience serious psychological distress. And to be clear, those numbers aren't overlapping. It's 25% are seriously distressed and 52% are moderately distressed. And unfortunately, but relatedly, suicidality is a critical concern, and the statistics are harrowing. There are over 1,100 suicides on college campuses each year. Next slide, please. So identifying at-risk students, what can we do to address student mental health before it reaches a critical point? First and foremost, develop robust policies and procedures to identify at-risk students and intervene effectively before tragedy strikes. So while you see on your screen a series of key indicators, this isn't necessarily an exhaustive list, and not every at-risk student is the same. So declining academic performance, increased social conflict or isolation, emotional dysregulation, concerning statements, or changes in appearance, these are all things to look for. And training staff to recognize these is crucial. So most staff are trained to look for injury or intoxication, but are they looking for the more subtle indicators like gradual changes over time? And we can go to the next one. So this is a very difficult situation to even think about, and one I hope that you and your institution are never faced with, but it's really important to discuss liability with respect to student death by suicide. So these facts are from a real case. It's one of the leading cases, recent cases on student suicide, and it's Wen v. Massachusetts Institute of Technology. So in this case, a student sought help from the university for test-taking challenges. He disclosed frequent suicidal thoughts, but he was not imminently suicidal. The university officials planned to keep in touch about the student, despite his repeated refusals to use school-affiliated mental health resources. So the student died by suicide on campus immediately after a call with a university official discussing his lack of professionalism in emails. His parents sued the university for negligence and wrongful death. Next slide, please. So the Massachusetts Supreme Court held that a university has a duty to take reasonable measures to prevent student suicide in the following circumstances. The university has actual knowledge of a student suicide attempt that occurred while enrolled or recently before matriculation, or the university has actual knowledge of a student's plan to die by suicide. And the court held that these circumstances were not present in this case. If they were present, then the university would be in what's called now a special relationship with the student, pursuant to which the university has a heightened duty to prevent suicide. Next slide, please. So how do universities, how do they meet this heightened duty? The best way to do so is a suicide intervention protocol. Where courts have found that a special relationship exists, courts generally look to whether the institution has one of these protocols and whether it was properly invoked. So here are some best practices for developing one. So first and foremost, if you don't have a protocol, create one. It should be aimed at identifying and appropriately referring at-risk students. Referral is one of the key features. Once a student is identified as at risk, they should be immediately referred to a mental health professional to assess their risk level. And adequate staffing of mental health professionals is key. So consider your student population, consider the frequency of suicide concerns, and estimate how often intervention will be needed and whether your staffing is adequate to support that. These protocols should also require professional assessment of risk level. So this can be low, moderate, or high. And the level of risk should determine the university's response. But in all cases, don't leave the student alone until they're assessed by a professional, and ensure that that assessment is done as soon as possible. This can be done by your own counselors, like I said, or if the staffing is not there, you can do it in coordination with community partners, so local hospitals and social services providers. But we generally recommend not involving law enforcement in mental health assessments unless absolutely necessary for safety reasons. The next thing would be to establish policies and individualized plans for student reentry after they are assessed as at risk and potentially have to leave the university or be hospitalized. So students who have attempted suicide are more likely to do so again, according to studies. So appropriate handling of reentry is really important. And the plan should be individualized, and we really recommend involving the student in the creation of the plan because this helps them to regain some sense of control. And they should also think about things like the length of time that the student was on leave, the academic program that the student is in, if the student is on any medications, if they have side effects or may need to be accommodated for those medications. And then what's the plan if the student experiences recurrent symptoms of suicidality? And then finally, it's always great to just have on hand a list of community-based resources for mental health. So things like this may be your own internal mental health professionals or local hospitals, local providers, or even national hotlines like the Suicide Prevention Lifeline. Next slide, please. And so this brings us to our fifth topic, which is campus safety. So moving to the next slide, safety on college campuses. Here are some statistics about campus safety from the Department of Education. As we know all too well, crime is a reality on college campus. The majority of crimes are burglaries and theft, followed closely by forcible sexual offenses. Next slide, please. So how can institutions identify and mitigate potential threats? So look for warning signs that someone is or may become a threat. And these include the person is threatening others, or they are engaging in outbursts, or their behavior is escalating in concerning ways, particularly over a short period of time. They seem emotionally dysregulated or unstable. They're exhibiting signs of substance abuse, or they're making statements regarding suicidality or a desire to self-harm. So what is a threat? A threat is an expression of intent to physically or sexually harm somebody. Threats may be spoken, they may be written, or they could even be gestures. They could be expressed or implied. True threats are not protected by the First Amendment. And it's also important when we're talking about identifying threats to note that the presence of mental illness does not equal violence or propensity for violence. The vast majority of those with mental illness are not violent. And because mental illnesses are also considered disabilities in many cases under federal law, institutions have to be really careful about assessing potential threats from students that have disabilities. And then we can move to the next slide on threat assessment. So one of the leading models for how institutions can do this effectively was developed by Dr. Gene Dysinger. He was the head of campus safety at Virginia Tech. Under this model, institutions can build a cross-disciplinary team of individuals. These are often high-ranking administrators from various offices, departments, as well as mental health professionals and campus safety administrators and leaders. So this cross-disciplinary approach really helps avoid silos of information and lets institutions see the complete picture and respond more quickly. It's important that these teams are well-resourced and well-trained. And we recommend that they have regular meetings, not just emergency as needed meetings. I think it's important that they can call emergency meetings as well, but regular meetings allow for monitoring and addressing emergencies or emerging situations that don't necessarily rise to the level of an emergency at that time, but may in the future. And finally, the team should have authority for emergency action. So, for example, administrative withdrawal or emergency removal, so that when a threat is identified, they can act immediately. Next slide, please. So once you have a team, it's important for them to be trained to assess threats. First and foremost, threat assessment should always be individualized, and it should be based on observable conduct and objective evidence. It doesn't need to be an adversarial process. The team can and often should talk to the student of concern and let them respond and hear their side of the story. In some cases, it may be appropriate for the team to ask for medical documentation, particularly for students with disabilities. It's important for policies to incorporate this, include this as an option, and to address any potential privacy concerns associated with medical information, often through student consent given via a waiver. Threat assessment teams should make their decisions, particularly those about emergency removal or emergency action, using reasonable judgment. So this generally means considering the nature, the duration, and the severity of the risk, as well as the probability that the injury will actually occur. So once you've assessed the risk, it's also important to consider whether the institution can mitigate the risks through reasonable policy modifications or through auxiliary aids or services. This is required for students with disabilities, but it's generally recommended for all students. And then when students are recommended for emergency action, the threat assessment team should also take into consideration what might happen on return. So if a student is removed as a potential threat, you can set conditions on their return. You may require them to complete counseling or to undergo a mental health evaluation. You can also require documentation demonstrating that they no longer pose a threat. Next slide, please. Okay, so I'm going to briefly touch on Clery because no campus safety discussion would be complete without mentioning the Clery Act. So under Clery institutional obligations, you must disclose statistics for Clery crimes that are reported to have occurred within your Clery geography and that have been reported to a campus security authority or to local police. And there are some exceptions we won't go too far into, but for example, like unfounded crimes, those aren't subject to Clery. Clery is really important because the failure to comply can be very costly. The current Clery violation fee is still about around $67,544, and we haven't heard yet if it will increase for 2024. But Husch Blackwell has designed a software application called the Clery Compliance Toolset that helps your team build confidence in your annual security report. So if you're interested in learning more about that toolset, please contact us. And now I'll pass to Alex to talk about minors on campus. Alex, sorry to interrupt. I think you might need to refresh because you're having the same issue I was having earlier with the audio. Apologies, guys, and thank you in the chat for letting us know. We appreciate you bearing with us.
Claire, can you give me a thumbs up if you can hear me now?
You're good.
Wonderful. Thank you so much. What I was saying is that I appreciate all of you giving us so much grace as we're navigating a brand new platform this morning that they chose to update. Maybe they knew we had this great presentation coming and they wanted to keep us on our A game. Claire and I were ready though. So thank you all for that, Grace, and appreciate all the questions that are coming through. We will absolutely be sure to answer them. But I just love all the feedback that we're getting in the chat saying, "Don't worry about it. It's no big deal." We're so grateful for all of you. Thank you for being so kind, and we appreciate it. So let's dive into minors on campus. I know this is a topic that a lot of you think about as it relates to the upcoming summer. That's why we've received a lot of questions related to it from our clients, and probably why it came up in one of our recent survey results. But it's really a topic that we think you got to think about during the whole course of the year, but we understand that as summer camps are approaching, that it becomes top of mind with the many other hats that you all are wearing. So if we move to the next slide, we'll start with who is a minor. And this is that typical lawyer answer of it depends. It depends on your state law, but it typically is anyone under the age of 18. This is in many states across the country. There's some exceptions that you can see on your screen, but be sure to take a look at what your specific state law is. If we move to the next slide, you'll see a map that we use when we're doing a minors audit to think through all the different ways minors might be on any given campus. This isn't really meant to be comprehensive because every institution is so different, but these are some of the places to look at for minors on campus issues at your institution. Your inventory of your institution's minors on campus may look different, but the important thing is to make sure that somewhere there's this kind of inventory taking place so that you can address how to handle those programs and minimize your institution's risks. If we move to the next slide, you'll see on your screen some practical implications that result from having programs involving minors. Because of time, we're not going to dive into each of these today, but the most common area we get questions about relates to mandatory reporting obligations. So making sure your staff have proper abuse and neglect training is going to be really critical in this area. If we move on to the next slide, you'll see that with minors and those practical implications from a logistics standpoint also comes potential civil lawsuits. We monitor this case law very closely because of how much work we do with helping colleges and universities with minors issues. On your screen, you'll see some examples of what has come up recently, many involving, they're sort of the themes that we see within it. Many of those relate to inadequate training, inadequate supervision, inadequate policies and procedures. So now if we move to the next slide, we can talk a little bit about the potential areas for risks and missteps and how to manage that risk. Let's start with supervision. Having a background check and procedure for your staff interacting with minors. Think about developing procedures related to travel with minors, ensuring your institution has procedures in place to evaluate and plan for trips with minors, including development of a trip plan to assess risk and ensure proper supervision based on the type of trip and the activities plan. And then another just sort of thing that popped in my head that I see frequently come up is thinking through pickup and drop off of minors with input from staff working with those actual minors on a day-to-day basis. Again, you want to have the folks who are implementing the policies and protocols helping you as you develop any policy or procedures related to this space. Pickup and drop off is a great area related to this. Figuring out what works, what doesn't, what are you already doing, and how do we make sure we mitigate risk in that space? Let's move to the next slide where we'll talk about mandatory reporting. Like I mentioned earlier, mandatory reporting usually is the #1 question we get related to this area, and it's very state dependent, so we won't spend much time on it here, other than to flag that you need to think through your state's laws on this and make sure folks are properly trained with their knowledge and obligations regarding reporting of known or suspected abuse and neglect. Again, the definitions of abuse and neglect are very state specific, and so what is a required triggering event for your state is going to depend on where you're located. So with that, I'm going to turn it back to Claire to talk about diversity in admissions and DE&I generally. Claire?
Am I unmuted? Awesome. Okay, next slide. Diversity in admissions. So we're going to be talking about the Supreme Court's recent affirmative action ruling. And at the outset, it's imperative that we acknowledge that this decision is controversial and it will have a very big impact, not only on how admissions professionals do their jobs, but also how institutions cultivate a diverse student body. So our goal today is to explain the decision as clearly as possible and to provide guidance on how you can comply with its terms while still pursuing your mission and upholding your values. So, students for fair admissions versus Harvard and University of North Carolina. I'll discuss the facts at an abbreviated level. Both these schools employed what they called a holistic review admissions policy, meaning that they didn't have specific racial quotas, but race was considered as one factor among many in the admissions decision. So students could gain a relative advantage, sometimes called a plus factor, if they were a certain race. So these schools were sued by an organization called Students for Fair Admissions, or SFFA, which is a group that was founded to advocate for race-neutral admissions. So they claimed that these admissions programs violated both the Equal Protection Clause of the 14th Amendment and Title VI. And obviously, the Constitution doesn't apply to Harvard as a private school, but the court explained that Title VI operates basically the same way as the Equal Protection Clause for purposes of this analysis. And so if an admissions program violates one, it violates the other. And I won't spend too much time on the prior rulings like Grutter and Bakke and Fisher, but other than to say that from 1978 until 2016, the court consistently recognized that there was a compelling interest in the educational benefits that flow from a diverse student body, and therefore allowed schools to consider race in admissions. No longer. The Supreme Court struck down the programs, so meaning colleges and universities can no longer consider an applicant's race as a factor in determining whether or not to admit them. And you'll see that in parens, I have scholarships there because while scholarships were not directly addressed by the decision, the same reasoning applies because scholarships are a legal benefit under the Equal Protection Clause and a program or activity under Title VI. So with this ruling, it will be very difficult, if not impossible, to have race-based scholarships, at least to the extent that they're funded or administered by your institution. And so the majority offered 5 reasons for this decision. The decision itself spans over, I think it's near like 250 pages. So I could talk about them all day. I'll try to, in the interest of time, keep it short. But essentially, they felt that the educational benefits from a diverse student body, that was too vague of an interest. It was hard to measure. There's no logical endpoint to it. There's no way to know when that's actually been achieved. Also, the admission programs as administered, the court felt they were overbroad in the sense that they grouped all Asian students together, even though there may be a significant amount of racial diversity within that group of people. And then they were under-inclusive in the sense that Middle Eastern students, they may not fall into one of the defined racial categories necessarily, or at least cleanly. They also felt the admissions processes were zero-sum. So even though the schools really emphasized that race was just one factor among many, and giving a benefit to a student of one race doesn't necessarily harm another, the court felt like it did, since students are competing for a finite number of spots, like giving an advantage to one person, the court felt was automatically disadvantaging another. So SCOTUS left open a narrow window to consider whether race has had a particularized impact on an applicant that therefore gives them an attribute that makes them desirable in terms of admissions. So for example, an applicant can write in their essay that they've experienced regular racial harassment and discrimination as a person of color in a predominantly white small town. And as a result of that experience, they've learned to be resilient. They write, "When I face adversity, I can overcome it. This will help me be successful in college and in my future professional endeavors." The institution can consider that this applicant should be admitted because they are resilient and able to overcome adversity. This is an individualized decision, though, and it will be applicant by applicant. Schools can also consider factors other than race that are facially neutral in an effort to improve diversity. So nothing about this decision would preclude your institution from giving preference to students from economically disadvantaged backgrounds or geographical areas where you don't get a lot of applicants or where a lot of people don't pursue post-secondary education. Similarly, first-generation college students can also still be given preference. But the bottom line is that race cannot be considered as race in admissions decisions. And similarly, race proxies are prohibited. So you can't use admissions essays or interview questions or indirect methods of ways of like considering race that would ultimately subvert the spirit and the purpose of the court's ruling. And this is a space that people are watching really closely because this opens the door for litigation against universities, for groups like SFFA to come in and say, okay, you have a facially neutral policy, but you're using it as a race proxy. And that would open the door to an examination and potentially a litigation of institutional intent, the intent behind those policies. So if you say you don't consider race, but you have verbiage on your website or admissions materials that suggests that you might be considering race, you're vulnerable to suit alleging that you're still making race-conscious admissions decisions in violation of the Supreme Court's ruling. So broader DE&I initiatives under this decision. So SFFA does not prohibit you from trying to recruit a diverse applicant pool. This is really important. So you can send recruiters to high schools with large populations of students of color. You can also engage in targeted social media or marketing campaigns intended to reach and attract applicants of color. It also doesn't prohibit you from engaging in efforts toward yield rate. So as long as you're not considering race within the admissions decision, once you've seen who you've admitted and you extend those offers, and you see that you can go and engage in efforts to basically improve your yield for applicants of color that had already been admitted. It also doesn't prohibit educational programs that teach the value of diversity, and it doesn't prohibit efforts to prevent or address prohibited discrimination and harassment. And so this brings us to our next topic, which is DE&I. So there are many reasons why universities engage in DE&I work. For example, the Office of Federal Contract Compliance Programs, or OFCCP, can audit your institution by reviewing your program for compliance with federal anti-discrimination laws. That's often an impetus for people to engage in DE&I work. The NCAA has also created an extensive DE&I review framework, which is required for participation. And then DE&I might align with your institutional or community values. These could include belief that diverse educational institutions prepare students for a diverse workforce, or students learn from those who have different identities than they do. You can still use DE&I efforts to promote those values within your institution, even if you can't consider them within the context of admissions. And then finally, many religious institutions engage in DE&I because they view educating a wide range of students as part of their religious mission. So key components of an effective DEI strategy. First and foremost, leadership support and top-down buy-in. So we strongly recommend appointing a chief diversity officer to lead and coordinate your DEI efforts, and we encourage having a direct line of communication between them and administration. And then depending on your resources, you can maintain a DE&I team either internally or externally. The best DE&I efforts are usually supported by robust data analysis and transparency. So use data to create accountability, to measure your effectiveness, to understand where gaps might be, and to inform opportunities for improvement. Do not use data as part of an employment action, decision-making, or to influence employment decisions. So don't develop racial quotas. And as a general rule of thumb, the closer the DEI goal is to an employment decision, the greater the legal risk is. We also recommend creating a communications toolkit. This helps determine the language that your institution will use to discuss and promote DE&I, and then to conduct DE&I trainings for all segments of your population. And finally, there's been some legislative and institutional pushback. So you may have seen this in the news. For example, in 2022, Florida passed the Stop Wrongs to Our Kids and Employees Act. It's also known as the Woke Act. This prohibits employers with 15 or more employees from requiring their employees to attend training or programming that espouses certain beliefs. So for example, statements where somebody might say an individual by virtue of his or her race, color, sex, or national origin is inherently racist, sexist, or oppressive. Those things are prohibited by the Woke Act. It's important to note here that any good DE&I training should not be doing anything that is prohibited by this law. But it's also important to note that there's potential liability under the law. The Florida Commission on Human Relations could pursue action against employers who are in violation, with damages up to $100,000. And then there's Texas. So we'll talk about Texas. We'll focus on Senate Bill 17, which actually took effect. Texas House Bill it's been in committee since March 2023, and people aren't expecting it to make much movement. But Texas Senate Bill 17 took effect January 1st, 2024, and it prohibits public higher education institutions from having DE&I offices or requiring DEI statements in admission and hiring. It also requires public universities to adopt a policy detailing students' rights and responsibilities regarding expressive activity. So, that policy and other policies of the university are required under the law to, quote, demonstrate a commitment to intellectual freedom and viewpoint diversity. The state of Oklahoma has also similarly ordered all schools to report their spending on DEI. So they're not necessarily restricting it. They've decided to start monitoring it. And then finally, we've seen some interesting developments at the institutional level. Some larger public universities in the South dissolving their DEI offices, absent state law requiring them to. So those are some examples of pushback that we're seeing in DE&I space. And now I'll pass to Alex to talk about web accessibility.
Claire, can you give me a thumbs up if you can hear me? Excellent. Look at that. Because I asked, therefore it worked, right? So that's going to bring us to a poll question today. For those of you who are in states that require polling, we wanted to make sure we at least got one poll question in today. So has your institution developed a website accessibility policy or otherwise identified web content guidelines that it will use to test your website? Yes, no, or I don't know. And we'll wait a few moments to have those answers come through, and then we'll dive into the legal background related to web accessibility issues. I'm seeing a great amount of folks participating. Thank you, everyone, for sticking with us. Okay, we'll close the poll in 5 seconds and look at the results. Wonderful. Let's take a look at where our audience sits on these issues. If we can move to the next slide. Okay. It looks like 50% of you have developed a web accessibility policy or some other guidelines that you're going to use to test your website, which is great. We have about 7% that are in the no category, and the 42% that are in the not necessarily I don't know. They're maybe in the I don't know right now, but I'm going to go back and figure that answer out category. That's what I want to put all of you in. Wonderful. That's a great benchmarker for our session, this portion of our session today. So let's dive into the next slide related to some background on the law regarding web accessibility. You're likely familiar with Section 504 and the portions of the ADA that apply to you, whether you're a public or a private institution. One part that I want to flag within these laws that relates to web accessibility is the communications requirement under the ADA, where an institution must take appropriate steps to ensure that communications with individuals with disabilities are as effective as communications with others. If we move to the next slide, you'll notice that the internet was in its infancy when the ADA was passed. And as you may know, there's no mention of the internet in the law itself. This has led to a lot of confusion as to what constitutes a place of public accommodation. So our website's a place. This depends on where you are, as there's a circuit split. Ideally, Congress would address this question, and a bill was introduced back in February of 2021 in an attempt to do so. Even though the courts are a bit all over the place on this issue, the holdings can generally be sorted into two main camps: those who assert websites are not places of public accommodation at all, and those who assert that they are. And on this sliding scale, some courts state that websites are only places when certain conditions are met, like when the website has a physical nexus to a brick and mortar location. This is just a smattering of recent cases, but you can see that the courts really are all over the map on this issue. So let's move to the next slide. And why did this make our top 10 list? We're seeing a significant increase in complaints, demand letters, and enforcement in this area. This is not necessarily unique to higher education, but actually across all industries. The lawsuits often state that plaintiffs tried to find information, tuition and costs, athletic apparel, school location, academic calendars, but were unable to gain access because the websites were not readable by a screen reading software. Some of you on the call may also be aware of enforcement action by the Office for Civil Rights within the U.S. Department of Education related to the issue of website and digital accessibility. Several have been resolved with remediation, some resulting in 302 agreements, but has certainly been an area of emphasis for this OCR. Let's move to the next slide, where we'll talk about the World Wide Web Consortium. This organization has developed the Web Content Accessibility Guidelines. Despite the absence of specific standards for web accessibility under Titles 2 and 3 and Section 504, we do have some generally accepted sets of guidelines for website accessibility. There was a proposed rule related to rulemaking over a period of several years ago by DOJ under the ADA, but the rulemaking process never resulted in regulations. This is really the area where institutions dive in the weeds about what constitutes compliant, accessible access. Here, your internal tech talent or external consultants or resources can be extremely useful in making determinations about web access and digital access. Let's move to the next slide. As you know, there's a broad range of information provided on your web pages and broad functions that individuals carry out through your web page, which affects students, faculty, staff, parents, alumni, donors, prospective students, the public. Who did I miss? As you're working through the area of compliance, think about accessing the information on your website in different ways. Keyboard users, mouse users, visually or only through sound, those sorts of things you want to really think through. Let's move to the next slide and talk about a list of compliance pointers. I'm going to highlight just a few of these in the interest of time. Let's talk about assessing your web presence. How many websites do you have? Are there links to third-party websites? What's your activity like on social media and any connections back to your institutional website? Gathering information from your internal team and external partners is really going to be critical in this compliance area. What internal talent addresses this compliance issue? How decentralized is the operation of your websites? And then think about establishing a policy and internal procedures like the poll question talked about. Establish a website accessibility policy. Establish internal controls to maintain accessible features. Those are some of the things that we typically see in this area as it relates to compliance. We have about 3 minutes left in the 1 hour session. Claire's going to talk about the borrower defense and its related regulations and compliance. We will stay on the line to finish out that section. We understand that some of you may need to hop off, and you will receive a recording with all of our commentary as well as the slide deck that comes along with it to share with others at your institution. Claire, I'll turn it over to you to talk about borrower defense.
Awesome. Thank you. And thanks, guys, for staying with us. I know we're going a little bit over, and I've seen some really great questions in the chat. So if we don't get a chance to get to those, we will get back to you after the webinar, even if it's via email, especially on the admissions pieces. I love to talk about that issue. So great questions. Thank you for those. So borrower defense. So this is our last topic. As many of you know, we have new final regulations for borrower defense to repayment. This permits a student who took out loans to apply to the department for loan forgiveness under certain circumstances. These regulations have a really complicated history. They're originally passed in 1994, amended in 2016, amended again in 2019, and now they've been amended again. With each amendment came a new standard for loan discharge, and the applicable standard depended on the date of loan disbursement, so it became very messy and confusing for borrowers and institutions alike. The Biden administration regulations, which took effect July 1st, 2023, they established a single standard for all BDR applications received or pending after that date. So if an application hadn't been ruled on by July of last year, then it's operating under one unified standard, the Biden administration standard. So the regulations also added several other things that we won't really delve into in the interest of time, but are important to know about. They introduced a new process for discharges when a school closes. They permit processing of group claims, meaning if the department determines that one student from a school has a defense to repayment under the standard, then it can group applications and process them in bulk under a rebuttable presumption that other students from the same school are entitled to the same defense. And third, if the department approves a BDR claim and discharges the loan, it now has the option to seek recoupment from the institution. We haven't seen a ton of that yet, but it now has that option. So the grounds for a BDR claim. You can see the grounds on the screen. This is under the current standard. I'm going to go through the elements, which the grounds are one feature of. So the elements of a BDR claim are, first, an actionable act or omission by the institution, which includes one of these 5 grounds. So a substantial misrepresentation, a substantial omission of fact, breach of contract, aggressive and deceptive recruitment, which is new, and a federal or state judgment or department adverse action against the institution that could give rise to a borrower defense claim. So that last one is somewhat broad, and it's meant to capture just enforcement actions. And then once you have that, that's the first element, then there needs to be detriment to the borrower from having taken out the loan and enrolled in the school, a causal link between the school's conduct and the borrower's injury, and that the appropriate remedy is to discharge the remaining payment obligations and refund the borrower's payments already made to the department on the loan. So going back to that first ground, substantial misrepresentation is a statement that's false or misleading, and it includes representations to accrediting agencies and state agencies, not just to students. And then for the purposes of BDR, the department has to conclude that their misrepresentation misled a particular borrower and caused that borrower detriment such that it warrants a full discharge and refund. And the standard for discharge is a preponderance of the evidence. So that's what the department's using when it's reviewing these applications. And institutional intent is irrelevant. So there's no requirement of finding intent or knowledge by the institution in order for a BD claim to be approved. So finally, aggressive and deceptive recruitment. We're highlighting this because this is a new basis that was added in the 2023 regulations. So make sure you and your admissions and marketing teams are aware of it. Essentially, if a school engages in aggressive and deceptive recruitment, when it demands or pressures you into making enrollment or loan related decisions immediately, it takes unreasonable advantage of your lack of knowledge about or experience with post secondary institutions, programs, or financial aid. It discourages you from consulting with others before making an enrollment or loan related decision. It obtains your contact information through websites or other means that falsely offer assistance to individuals seeking benefits, state, local, or federal. It falsely advertises employment opportunities or presents false rankings of the institution or its programs, uses threatening or abusive language, or repeatedly and unsolicitedly contacts you for enrollment after it asks you to stop. So those are all things I'm sure you're not doing, but also things that we want to make you aware that the department is now approving BDR claims on the basis of. So thank you very much. I'm going to pass to Alex to see if we have any time for questions or otherwise wrap up.
Thank you so much, Claire. Appreciate it. Can you give me a thumbs up that you can hear me so we can close this out? Excellent. We have one more minute left, so if you want to get in your last questions in, we will make sure to answer those via email. Thank you for joining us today, and thank you so much for helping us navigate the new tech and the new webinar here in 2024. We hope the information was helpful and useful to your institution. Like we said at the beginning, this was prompted by your feedback on wanting a potpourri of topics that we may need to think about in 2024. And so we hope that it was as useful as we tried to make it. As a reminder, this program has been approved for legal education hours. To report your hours, click on the CEU icon at the bottom of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Be sure to complete that short survey. We will use your feedback to plan future programs that are applicable to your institutional needs. This concludes our webinar. Thank you.